Welcome to Petro's Family Wealth. Today we're going to cover some estate planning for folks that have a $3 million or more of net worth, and in particular around their estate plan. And so what we're going to cover today is the impact of Minnesota's estate tax limit. So let's go ahead and dive in. Here at Petro's Family Wealth, we're here to arm you and educate you, and so none of the things that we talk about are going to be investment recommendations specifically to you. This is purely going to be from a concept standpoint to arm you, educate you, and help you and your family be able to keep the wealth that you and your family created together. This is a estate flow chart. So what we have here is a husband and a wife, and they have a traditional will, but they don't have any trust being created at their passing. They've been very successful both on the financial side of things and the family side of things. So they have about $5.8 million of wealth between their houses, the investments, whatever assets that they have. And currently it's tilted slightly a little bit more towards the husband and a little bit less to the spouse, to the wife. If they both were to pass without any advanced estate planning, when they pass, all their wealth will go to their 4 children. However, in order to get there, the clients would have to open probate. They would also have to file estate taxes, because here in Minnesota we have essentially that estate tax is called a death tax for any dollar over $3 million. And it's a prorated amount, but I'm using about 15% as the average, just to make things a little bit simpler to look through. So here at the husband's passing, you can see his wealth transitions through probate over to his spouse. Now, things that are held in the joint account, so joint assets, that might be a home, that might be joint checking, joint investments, that'll pass over to the wife without going through probate. Then, when the spouse passes, when the wife passes, what will happen is an estate account will be created, probate will be created again, and through the court system, it'll generally be determined that it'll go to the kids, unless there's any mental health issues or physical issues where they're still dependent on others. But let's say that they are full adults. They would each receive, after the estate taxes of around $420,000, they would each receive around $1.35 million. Now, when somebody looks at this, when I share this with clients, what I say is, as long as the attorney costs less than $420,000, you made money, or your family made money. Attorneys can be quite expensive, but the reason why they're expensive is a lot of times that they're worth it. So let's go through a couple concepts, a couple ideas to share how to preserve that wealth for the next generation. But the other thing real quick I want to touch on is a lot of times when children receive some wealth, depending on their age and the maturity level, sometimes they may not, that wealth might not be a net benefit to them. It might be a detriment to them, their families, and their financial journey. And so in this particular case, the kids would just receive the assets outright because they're adults over the age of 21 for Minnesota. So let's dive into a couple estate tax saving tricks. The first one is utilizing revocable trusts for the husband and the wife, where assets are transitioned. Instead of husband's assets, it's husband's revocable trust assets. Same thing for the wife. And then the wife's assets are going to be in the wife's revocable trust. So the first step typically is the actual creation of the trust documents. But one of the things that I see, one of the mistakes I see, is that even if you create the trust, you're not funding it, or you're not retitling assets from wife to wife's revocable trust, or husband to husband's revocable trust. And a lot of times that can screw up an estate plan after somebody's passing. So it's not just creating the trust, you actually have to retitle assets in the name of the trust in order for it to be effective. So that's the first step. And when husband passes away, what we're going to do is the $3 million of the husband's assets is going to transition into what's sometimes called a marital trust, sometimes called a disclaimer trust, sometimes called a family trust. But what that trust is, it's an irrevocable trust. So it preserves the husband's assets, and then it stays in that trust. Now the wife, the spouse, can receive income and can receive principal from it, and potentially on the principal side, it's usually after her other assets are reduced or whittled away or used up for lifestyle expenses. But the purpose of that is that's going to preserve the husband's $3 million of Minnesota estate tax limit. Then, when the wife passes, she's going to also have $3 million estate tax limit for Minnesota. And so as long as her assets are under that $3 million, all the assets at both of their passing will transition to their kids. And so that'll save the $420,000. Now when the assets transition to the kids, the assets can stay in a trust for their benefit if you wanted, or it can just go out to them outright, depending on the age, maturity, and the particular circumstances and your wishes, because of the wealth that you built. So that's one way. That's called a revocable trust, and using a marital trust to preserve both spouses' $3 million exemption. So that effectively doubles the $3 million Minnesota estate tax limit from $3 million to $6 million. But let's cover what if we didn't have this trust or this estate plan set up at the husband's passing. And so right in the middle there, as far as after the husband passes, all the assets transition to the wife. One of the things that the wife can do if she wants to preserve some of that wealth for her kids, or if she's not going to be spending down all the assets for her needs, she can do is she can make a gift to an irrevocable trust. And what that does is she's using her lifetime exemption on the federal side of things. So federal and state both have two different limits. But the thing is that federal has a gift tax and a death tax, whereas Minnesota has just a death tax, not a gift tax. And so when the wife gives $3 million to an irrevocable trust, she's using her $3 million of her lifetime gift exemption on the federal side. And so long as that trust is in place for 3 years before she passes, now those assets are now exempt from Minnesota estate taxes. Because remember, that's a death tax. But there is a 3-year look back for estate tax purposes for Minnesota, which is different than a Medicaid 5-year look back period. So there's still an option for the spouse to preserve the wealth that her and her husband built even after her husband's passing. But some of the keys here is when she gifts those assets to the irrevocable trust, she cannot be in control of those assets. So sometimes it's a independent trustee, a corporate trustee, a very studious and trustworthy friend or a family friend or multiple folks that are in control of those assets. And it's going to be for the benefit of the kids. So as long as she's comfortable giving up that type of wealth, because she's not going to be able to receive income from it, she's not going to be able to, if there's a house in there, she's not be able to live into that house unless she rents from it. She really does have to give up that control in order to be effective to get outside of her estate. So there's a number of trade-offs in this plan, but if you are in that situation, link up with your financial advisor, link up with us, and we'll guide you through it. Thanks so much for your time.